Arbitration is a very fast process, and in some exceptional cases, it may only take a few weeks until the matter is decided. Now, this happens very, very seldom. One must be clear about that. The average duration is still several months, and I think if you can get an arbitration done within a year, then that's usually quite good. However, even if you can get the dispute done in a matter of, say, 8 weeks, this can be way too long in some instances. Sometimes there may be an imminent danger that one party is severely disadvantaged, or that it runs the risk of losing a lot of money, etc. If a minor issue, not the whole thing, but a minor issue were not decided immediately. This is when interim measures are coming into play. Now, in arbitration, there are usually two forms of interim measures. There are those issued by the arbitral tribunal and those issued by the court. Both are happen quite often from my own experience, and the joke that is often told that interim measures are like unicorns, namely that everyone knows them, but everyone has still to see one, is, at least from my experience, certainly not true. The lecturer for this session, Stephen Lim, can speak from his own experience as an arbitrator and does speak so. So clearly from his experience as well, interim measures are not something which is just a theoretical topic, but are indeed something which you will see happen in real life. But who is Stephen? Stephen Lim is an arbitrator and barrister at 39 Essex Street. He has sat in numerous international arbitration proceedings as an arbitrator in really various different roles, including emergency arbitrator. And that, despite their popularity, is still something that I think a lot of arbitrators out there envy him for, because they haven't managed to do that yet. And prior to becoming a full-time arbitrator, so to say, he has been practicing as a counsel for many years, receiving many accolades for that role. Stephen, now to you and interim measures.
When we look at interim relief under the Arbitration model law, it is important to bear in mind the differences between the 1984 model law and the 2006 amendments. One of the biggest changes in the 2006 amendments was on the provision on interim relief. While the 1984 model law has been adopted in 83 countries, 116 jurisdictions, counting various states and federal countries, only 26 jurisdictions have adopted the 2006 amendments. So the 2006 amendments presently have limited application. I will discuss both the regimes of interim relief under the 1984 model law and the 2006 revisions. First, it is important to bear in mind the model law provides a choice to parties to obtain interim relief from a court or a tribunal. The model law recognizes it is not incompatible with an arbitration agreement for a party to request interim relief from a court before or during arbitral proceedings. This is in Article 9. There may be differences between how a court or tribunal decides the application for interim relief. Parties need to carefully consider whether the application should be made to the court or a tribunal. I will discuss this further towards the end of this lecture. I'll now focus